It is definitely a great privilege to moderate and facilitate this session. We are also honored by your presence and look forward to an exciting and interactive session. Members, as I make my opening remarks, I am sure you would agree that litigation is not as we used to know it. The hustle and bustle of shuffling through courtrooms and corridors, our hands heavy with files, strangely feels like a distant memory. The thrill of appearing before the court and addressing the court physically, eyeball to eyeball, has now been taken away by this pandemic. The courtroom is now a window or a tab at the corner of our computer screens. We now sit in the comfort of our offices and not the usual wooden pews, as some of you might remember them. We multitask while in court, and instead of shuttling from courtroom to courtroom, what we do is we minimize and mute the court. Unfortunately, there are advocates who, after being admitted, and particularly after the pandemic, may never know the joy of appearing physically before the court. Members of the bar, times have changed and we must change with it. In the same way we cannot pour new wine into old wineskin, we cannot proceed with old practices at such unprecedented times. Being unexpectedly launched into the virtual world has definitely had its set of challenges. To start with, I think there's a lack of trust on whether a case that is conducted virtually carries with it the same veracity as one that is conducted physically. Secondly, I also think that the court misses out on the demeanor of a witness when it's looking at a witness through a screen. We as advocates definitely miss out on opportunities to build up our case, to walk towards the dock and bring down our case. And of course, there are instances, though we hope not, but I suppose there might be instances where advocates could use this as opportunities to coach their witnesses through trial. Finally, and most unfortunately, there's the casualness by some advocates in conducting virtual proceedings, which we fear may dilute the profession, if not nipped in the bud. The courtroom is a core component of justice, meaning that the courtroom must be revered. We must trust that hearings, regardless of the fact that they are virtual, will be conducted with integrity. Even in a pandemic, courts need to function in a manner that is consistent with the institutional role and essential characteristics as stipulated under Section 1A and 1B of the Civil Procedure Act. So these practice directions are meant to streamline and regulate practice and procedure, and our panelists plan to take us through them. As Socrates said, it is our role to focus our energy, not on fighting the old, but building the new. So we welcome you, and to assist me in welcoming you is the current chair of the LSK Nairobi branch, Ms. Helen Namisi. Helen Namisi.
Thank you, Ms. Muraguri. Good afternoon, ladies and gentlemen. My name is Helen Namisi, and I am the chair of the LSK Nairobi branch. I would also like to welcome you to today's Inns of Court, which is the first, actually, not only for this division, but for the entire branch in the year 2022. The Inns of Court for us is a forum where the practitioners can address issues that are pertinent to a particular area of practice in that division or in a particular court. And so we are very happy to have you here this afternoon, quite a number of you actually. I can see we are over 130. We welcome you this afternoon, and we hope that you shall have fruitful deliberations. We are also very honored to have with us Honorable Justice Alfred Mabea, who is a very key supporter of branch and branch activities. We have Senior Counsel Fraser, We have Honorable Tanui, who we know from the e-filing and the success thereat. We have Senior Alan Gishui, who is also instrumental in this particular division. And of course, our moderator, Stella Muraguri, who has just given the opening remarks. So on behalf of the branch, I want to say, Karibuni. Please feel free to listen to the presentation that will be made this afternoon. Ensure that you use the chat section for your questions. And let's try to understand and appreciate these practice directions that were gazetted in January 2022. As Ms. Muraguri has said, it is onward. We cannot go backward to the pews and the wooden benches. Practice must move forward. It is dynamic and it must move forward in a dynamic society. So with that, I want to take it back to you, Stella. Enjoy your afternoon.
Thank you so much, Helen. Next, I'd want to welcome the PJ of the Commercial Tax Division, the High Court, Milimani, Justice Alfred Maber.
Thank you, Stella, as well as Helen. Thank you, everyone, for being here this afternoon. It's my privilege to be I'm happy to be accorded this opportunity to be with yourselves, make some remarks, and share my few thoughts during this fourth Inns of Court meeting, which has been hosted by the Commercial Tax Division in conjunction with the LSK Nairobi branch. As we know, the concept of Inns of Court is largely borrowed from the UK as well as the American jurisdictions. It is an association of lawyers, judges, and other legal professionals from all over, from all levels and backgrounds who share passion for professional excellence. Through regular meetings, members are able to build and strengthen professional relationships, discuss fundamental issues as well as concerns about professionalism and pressing legal issues of the day, and as well as share experiences and advice, exhort and utmost passion and dedication for the law, providing mentoring opportunities and advance the highest levels of integrity, ethics, as well as civility. Our Inns of Court have been forums where honorable judges, as well as distinguished lawyers serving in and practicing before the Commercial Tax Division have answered the question, how do we make the Commercial Tax Division more effective and efficient? Stella has mentioned the challenging times that we have undergone for the last 2 years and the changes that have come with the pandemic. This meeting follows, I believe, the third Inns of Court meeting that was held sometimes in December 2019, where senior counsels and judges had a conversation in the presence of the Honorable Chief Justice Emeritus Maraga on unlocking the commercial court. The division, being a specialized division established way back in 1997, with the two main objectives: make litigation faster, fairer, and more accessible to the business community, and enhance foreign investment through fostering investor confidence. The judges who serve in the division have worked tirelessly to create a respected forum for resolution of business. However, a backlog of cases still exists. As at the 28th of February 2022, the last day of last month, the division had 5,663 pending cases. Ideally, all these cases have to be heard and determined within 360 days from the date of initiation. That is the contract the division has with the judiciary. To enable us to do the same, case management strategies have to be developed and have been developed and implemented. One of such strategies is the practice direction and proceedings before the Commercial Tax Division in Nairobi, which was gazetted by the Honorable the Chief Justice Martha Koome on the 11th of January 2022 and pursuant to Gazette number 190 of 2022. They came into force on the 1st of March this year. Therefore, I think they are 29 days old. And these practice directions provide for case management conferences. A fundamental part of that system is that all matters necessary for the hearing of cases are resolved before the case is set down for hearing. When the judge certifies the matter as ready for hearing, the judge will, in consultation with the parties, assess the time needed so that the case can be concluded at the first hearing. The aim of the practice direction is to enable judges to spend most of their time hearing and determining substantive cases. The purpose of this meeting, therefore, today is to explain the practical implementation of the practice direction and have a discourse around that area. Let me take this opportunity to thank the subcommittee, which was chaired by the Honorable Justice Grace Ngenge and Senior Counsel Ken Fraser, for coming up with the first draft of this practice direction, which was subjected to public participation. And I believe most of you, learned counsels, you participated and you gave your views. It was polished up and as well polished up and enriched by the Office of the Chief Justice before gazettement. I also wish to thank the Law Society of Kenya, Nairobi branch, through the convener of the Commercial and Tax Division, Bar Bench, Madam Stella Mraguri, for hosting this meeting. Before I invite the panelists, I know on presence, all the judges of the division are here present. We'll be following this, which I believe will be very, very engaging discussion this afternoon. And let me therefore take this opportunity to invite the panelists, led by the able Senior Counsel Ken Fraser, Senior Counsel Allen Geshohe, and Honorable Elizabeth Tanui, to lead the discussions. Good afternoon and thank you.
Thank you, Honorable Justice Alfred Mabea. So to start us off is Senior Counsel Fraser, who's our first speaker. Senior Counsel Fraser is a known titan in practice and a litigator who breathes life to the law. He is a barrister of the Inner Temple and has been an advocate of the High Court of Kenya since August of 1970. He's a stickler of practice and procedure and brings with him a wealth of expertise into this discussion. I have had the pleasure and privilege of jostling with him in court, and I can boldly state that he is extremely meticulous in his approach and detailed to a fault. Senior Counsel Fraser was a key component in the drafting of these particular directions and has dedicated himself in simplifying how we practice the law whilst not departing from the rule of law. Senior Counsel Fraser, welcome, the floor is yours.
Thank you. The notice for this meeting refers to Inns of Court on practice directions, and directions is in the plural. And while the emphasis is undoubtedly going to be on the practice direction on proceedings before the Commercial and Tax Division, we cannot lose sight of the practice direction to standardize practice and procedures in the High Court, which was gazetted as Gazette Notice 189 of 2022 and was published on the same day. There is some duplication between the two practice directions. For me, if any proceedings are pending in the Commercial Division, the Commercial Practice Direction will take precedence on such matters as pleadings, witness statements, case management, and hearings. There are, however, several areas in the General Practice Direction which we must be aware of. Item 9 is dealing with format, which is going to be important for us because it sets font sizes, margin sizes, and line spacing, which will greatly reduce the amount of information we can get on a page. So we need to be careful in negotiating how many pages we're going to write in our submissions. There's also useful stuff in item 24 on the restriction on when cases will be listed for mention and how they get listed. And in item 38, there's a change from the old court rate of interest of 12% in the 1982 practice direction to 14%. A matter for discussion is that only applies to the High Court, and it leaves the Magistrates' Court still running at the lower rate of 12%. This practice direction is a combination of the earlier practice direction that we had in 2014 on case management, with new matters added into the case management portion to deal with the concept of virtual and physical hearings. And as Mr. Justice Mabea said, the second part is on actually conducting virtual hearings and how we deal with witnesses and statements of evidence. And that was submitted to public participation before the Chief Justice asked us to combine the two practice directions into one. The preamble to the practice direction makes clear that it applies to all proceedings before the Commercial and Tax Division. That's mentions, directions, case management, submissions, hearing of applications, and the main hearing of the case generally. The introduction, which unfortunately has lost its numbering in the Gazette notice, should be listed as item 1. It sets out that for the Commercial Division, the practice direction replaces Order 11. So if we've got cases pending in the division, we shouldn't be referring to Order 11. We should be referring to the practice direction. It also records the satisfaction of the judges in the Commercial Division that conducting hearings on teams complies with the requirements of Order 18, Rules 3 and 4 of the Civil Procedure Rules regarding witnesses being present and the judge recording proceedings. Most importantly, it makes clear that the virtual proceedings and judgments and orders made virtually have the same effect as physical proceedings, judgments and orders. So we must get away from the idea that virtual proceedings are informal, we can turn up in our beach shirts and so on. It has the same formality and the same seriousness as proceedings in a physical court. And finally, on the introduction, I would draw your attention to paragraph B, which makes clear that the court will strive to complete all hearings within 90 days from the commencement of the hearing. So while, as Judge Mabea said, the desire is to finish a hearing on the day it starts, the intention of the judges is that we will not have lengthy adjournments. If something starts, it will be finished within 90 days. The case management portion of the practice direction starts at paragraph 2 in the practice direction. I think it's important for us to remember that the Civil Procedure Rules 2010 made two very fundamental changes to the way in which we used to conduct proceedings. The first was that we're now required to file our statements of evidence and bundles of documents with the pleadings, not work on this over the length of time between close of pleadings and the hearing date. In practice, under the old rules, that generally, I think, meant running around in the last 2 days before the hearing started, trying to find your witnesses and your documents. We're now required to do all of that up front. And the second aspect was the introduction of case management, or I should say the reintroduction of case management, to see that the parties are complying with the requirements of the rules and that everything is ready to move forward. The problem with the old Order 11, as it originally introduced in 2010, was that it was very bureaucratic with far too many forms to be filled out and far too many appearances. And when Mr. Justice Musinga took charge of the division in 2012, he produced a practice direction to shorten a lot of the documentation and to try to make the procedure more consistent with the aspirations of a commercial court of giving speedy decisions efficiently and cost effectively to commercial people. That assisted greatly, but when Mr. Justice Kimondo took over the division, he had a meeting with the judges and he came to the bar bench to say that the judges felt that the practice direction had not gone far enough, that the judges wanted to take control over the way in which proceedings are prepared and the preparations to see that they are ready for the hearing. And he set up a subcommittee of the Bar Bench Committee, which was chaired by Mr. Justice Havelock. We had very clear directions as to what the judges wanted to see dealt with in that practice direction and to ensure that cases really were ready to move on for hearing when they were set down. And that led to the 2014 practice direction, which has to a very large extent been adopted in the new Order 11 brought in 2020, but not entirely. That 2014 practice direction is now subparagraphs A to P in the present practice direction that we're now looking at. The COVID pandemic has opened our eyes to the possibility of virtual proceedings, and I would think it made us accelerate our move to virtual proceedings by 5 or 10 years. And we must take advantage of what we've been forced into doing, which will save greatly on time. The transition between one case to the next case in court proceedings has been shortened. We're saving on travel time. We have the luxury of continuing to work at our desks while we wait for our case to be ready, and we can have all our papers ready instead of trying to balance them on the end of a table and find the right page and so on. So there are many advantages to this. There are some disadvantages which we will discuss during the course of this afternoon. Whether we look at a virtual hearing or a physical hearing, the intention is the same: to do justice while making the best use of judicial time. What exactly does case management in the commercial division require? Firstly, after the close of pleadings, any party may file the case management checklist. And I emphasize any of the parties can do that. You don't need to wait for the plaintiff. If you file the checklist, you must fill in the preliminary matters in items 1 to 4, which we will look at in a few moments. Then you serve that and you invite the other parties to fix a date at the registry for the case management conference. 7 days before the case management conference, all the parties should file a request, which is in the prescribed form in Schedule B, which sets out all the things that you want to have the court consider in the directions. At the case management conference, the judge will go through the directions, will take control of the areas where he thinks the parties are not concentrating, and eventually he will set the case down as ready for hearing and fix a hearing date. The practice direction does say that case management will normally be on a Friday. That was a subject of considerable discussion because I think that rule is broken more often than it is honored. And the feeling was that normally suggests flexibility so the judges will decide when they are most comfortable dealing with case management. So it won't necessarily be on a Friday. The idea is that the judge will hopefully have 10 or 15 minutes to look at the matter, and it won't just be rushed through as a short mention would normally be. It is, however, very important that if the case management is to be effective, that the advocate who has the conduct of the case or someone who is working closely with him and is very familiar with the case should be attending case management. It's not something for sending the newly admitted advocate along. You need to be ready to answer questions and for the judge to be asking you whether something can be agreed upon, whether concessions can be made. So you need to be there with somebody who has control. It's very sad when you hear a judge asking, can we do this or that? And a very young lawyer is just saying that all I've got is instructions to say we have complied. It has to be more than that if case management is to be effective. The case management provision at paragraphs L and M provides for how bundles and statements of evidence are to be prepared. Every page in the bundle of documents should be numbered. We recommend at the foot of the page, leaving the top right-hand corner for any appeal to the Court of Appeal. It's desirable that your documents should be in chronological order because that facilitates both the judge and the other parties following the flow of the documentation. But there is flexibility if you in your discretion feel that it would assist for clarity and understanding to separate the securities or to separate reports or opinions or pleadings in another case into a separate section of the bundle, then you have that flexibility. But clearly mark the different sections and clearly number each page in chronological order in its section. It's also desired that we keep the documentation as small as possible. So if the plaintiff has already included a document you want to refer to, there is no need to put that into your bundle of documents. You can simply refer to page X in the plaintiff's bundle and deal with the matter there. It's only if there is some material change in your copy of the document or something important that you should duplicate the documents in your bundle. There does seem a tendency by some advocates to feel that they have to put every document that they want to put in because it is my bundle. We should be looking at this as our bundle for the hearing of the case and sharing the documents across. The requirement on statements is that it should identify all documents referred to or relied on by reference to the page number in the bundle. And I emphasize relied on, because there is a practice of just throwing in hundreds of documents, not referring to them in your statement of evidence. So neither the judge nor the opposing side know exactly what they're there for, but just in some forlorn hope that if something happens, you may find the answer in that bundle. Documents in the bundle should be identified in the statement of evidence and clearly show why they are there and what purpose they are serving your evidence. This will facilitate cross-examination and will avoid lengthy re-examination in reference to documents for the first time and objections that follow from that. The intention is that at the hearing, the witness will adopt his statement of evidence and produce the bundle of documents, and there should only be minimal highlighting before the witness is subjected to cross-examination. This does mean that it's important that we see that the statement represents what the witness himself wants to say, and that everything that the witness wants to say is actually set out in that statement. We're aiming to eliminate surprise and avoid judgments while people try to take instructions for cross-examination. One of the aims of the case management is to reduce the size of the cause list. If you look at the judge's cause list each day, probably there's 20 matters which are applications or mentions. And the practice direction provides that, save in the case of an injunction filed simultaneously with the plaintiff, all applications that you wish to make, whether they're for particulars, for discovery, for interrogatories, or amendments of your pleadings, should be made as part of the case management conference. When we look at the checklist, we will see that there's provisions for making your application in the case management request and getting that dealt with at the one hearing. This will enable the judge to make all the relevant interlocutory decisions at the one time and focus on seeing that everything is now in order and the case is ready for hearing. There will still be some mentions, but hopefully if we all follow this and endeavor to deal with everything at the case management, we will greatly shorten the cause list, and as Judge Mabea says, allow the judges to get on with the important work of hearing substantive cases and determining them. Important bits on applications is that on an injunction application, either during when it comes up for hearing or delivery of the ruling, the judge may proceed to convert it into case management and give immediate directions for the hearing. This would greatly shorten things if a judge could direct that the affidavits are treated as the pleadings and statements of evidence and get on straight away to a substantive hearing, rather than the situation we have just now of arguing everything on the injunction application as a sort of rehearsal for the hearing, and exactly the same material is dealt with again at the substantive hearing. The affidavit in support of the application may refer to documents in the bundles. So there's no need to attach a great bundle of exhibits. If your bundle is there and the documents are there, you can refer in your affidavit to page X in the plaintiff's bundle, page Y in the defendant's bundle. And we save the bulk of documents that have to be filed and looked at. One thing the judges were adamant about when we were doing the 2014 practice direction is that any application to strike out should be made at or before the case management conference, and that they will not deal with applications to strike out subsequently. So if you feel you've got grounds to strike out, you need to get that done at or before the case management. Something that is new from the 2014 practice direction, but was carried forward from Mr. Justice Musinga's 2012 practice direction, is paragraph 2(n)(5), which deals with certificate of urgency. It sets out how you apply for urgency, and it also gives you the right to ask for an oral hearing before the judge if your certificate is refused. That's a practice that not many people had remembered from 2012. What is also new in the case management section is the portion from paragraph Q to paragraph U, which is dealing with the questions of the directions to be given for a virtual hearing. And one thing I would draw your attention to is that the judges did say that the default will be that hearings will be virtual rather than physical, so that we have to make out special grounds if we want a physical hearing. I would like to, if Honourable Tanui can let us look at the Schedule A. Is it possible to put Schedule A up on the screen? I think we're getting there.
Okay.
A bit further on. There we are, Schedule A. Thank you. Now, this is the case management checklist. And when we go through this, you will see the simplicity of the system and why it's not such a hardship. The first thing is that, and the first line, the nature of the claim. The judges had indicated to us in 2014 that they found it helpful to have a very brief idea of what the case is about, whether it's a mortgage suit or a bank loan recovery or an insurance claim. So it's just a 4 or 5 word description of the claim. Then you have to fill in the case number, then the names of the parties, the plaintiff and the defendant. And we were asked that we should insert in there the name and address of the advocate. This is to facilitate for the court being able to contact the parties if there is any need to do so. Then we get down to the body of the checklist. So the first thing we have to fill in is the details of the pleadings that have been filed, the plaint, the defense, and the reply. Then we get down to the details of the statements of witnesses and the bundles of documents, both for the plaintiff and the defendant. Now, if there are additional plaintiffs or defendants and you're using a soft copy of the form, you can put in extra boxes for first defendant, second defendant, and so on. These are the preliminary matters, paragraphs 1 to 4. And the tendency nowadays is that the deputy registrars will look to see whether these have been filled in. And if there is any gap, somebody hasn't filed their statements or their bundles of documents, it will be immediately visible from the first page of the checklist what is missing, so the deputy registrars can give directions on when those should be filed. And as you will see, they have power, firstly, to make an order for compliance, and then they have a space for an unless order. In other words, making a default order that if you fail to comply, either you won't be allowed to produce evidence or your documents, you're not allowed to produce documents. So there is a provision for default. Now, one of the things that horrifies me when I'm listening to case management is, firstly, the question that is asked by registrars and judges is, have you complied? To which the answer is usually yes, or though often with some uncertainty, or maybe I want more time to file this or that. this is not a question of the end of the case management. You do not comply with case management simply by filling in the first page. We had a system of summons for directions mid-1970s and 1980s, which had a long 4-page menu of things that you could ask for. And that was so frustrated, it ended up being just asking for the last prayer hearing in Nairobi 2 days, and it got repealed because the lawyers, and I'm afraid the judiciary assisted the lawyers, just did not treat it seriously, and it got abandoned. Compliance is far more than filling out numbers 1 to 4. So if we can move on then to the next bit. The first question that comes up at 5 is alternative dispute resolution. And I think it's now agreed that the best time to decide whether a matter should go to mediation is when the pleadings have been closed, the statements have been filed, and a judge is looking at it. So you can anticipate that on the case management, you will be asked, should this go for mediation? If not, why not? So you should be ready to deal with that. Then when we go to 6, we find a series of questions relating to pleadings. Do you want to amend your pleadings? Do you need to file additional witness statements, additional documents? Do you need particulars? Do you need interlocutory relief? Do you want to apply to strike out? And at 12 is other applications, because although discovery is no longer in the rules, there's still a provision for it in the Civil Procedure Act, so you may want to ask for other things. The idea is that you can attach your application to the request form, which we will look at in a second or two, and simply say that you want to amend your pleadings as shown in the document attached, or you want to file the additional witness statement attached. And that way you can deal with all of these applications at the same time. I should add that the request form is the absolute mirror of the checklist from question 5 onwards. So then we get to 13. Are there any objections to admissibility of any statements or documents or any part thereof? And when should such objection be determined? And this is important because people throw all sorts of hearsay statements into their statements of evidence. There are documents which are disputed and you want the production of the original. These are matters that we should be thinking about early on in the case. And the intention is that you should raise this on the case management conference to indicate, I have a problem. I object to that statement as hearsay. I object to this document as not being genuine. I require the production of the original. These matters should be brought out at this stage. And there's boxes for your objections, and the judge will fill in what the directions are on that. 14 is the important point, question of issues. It is the obligation of the judge to frame the issues, but the judges expect us to at least make an effort at doing this and to agree the issues. And I know one of the judges will insist that we agree the issues before he certifies the case is ready for hearing. Then at 15, there are some questions about how the case will be dealt with. Does it need to be consolidated with another case? Is there an agreement for a case stated for the opinion? Do we want to have a test case? So if we have over 10 cases on the same matter, you may want to either consolidate them or treat one of them as a test case. You can attach your application to the checklist and have that dealt with. Then come a series of questions directed at your witnesses and the evidence. Do you need witness summonses? Are there admissions of statements of evidence so there's something that's very minor? Are you prepared to agree that that statement can be admitted in evidence without calling the witness? The aim is to reduce costs and to reduce the time of the hearing. Do you need to put some evidence in on affidavit? Do you want discovery, production, or inspection of documents? Do you want interrogatories? Examination of witnesses on commission if they're outside the country, which isn't so important now because we can do a virtual hearing from outside. And do you need directions regarding examination of accounts? All of this designed to make us think about how we're going to present our evidence, what is really an issue, and can we shorten the amount of evidence that has to be called. Which then leads on to 23, which is expert reports and directions from the court as to which experts are we able to agree on expert evidence, directions for exchanging those expert statements, because what the experts say may have an impact on how we want to proceed with the case. 24 is whether we need directions regarding the production of a chronology, where there's a lot of different transactions that have happened, and it's important to see the time sequence. Do we need maps, plans, or diagrams? The hope being that such things can be agreed on and put in as agreed documents. Then we get to 25, which is dealing with the hearing. First of all is seeing that there's an index bundle of all pleading statements and documents filed by the parties. Are we doing it physically or virtually? And if so, are we putting together a physical bundle, or are we ensuring that the bundle is available virtually? This is important because we have to see that our witnesses all have access to the documents so that they can answer questions. How much time is required for the hearing? And this is always difficult because you never know how somebody's going to respond in cross-examination, but we should make genuine attempts to try and work out how long it will take. Then the important new question, should the hearing be physical or virtual? As I said, the default will normally be virtual. And then, is the case ready for hearing? And the judge can certify it. The expectation is that as the judge works his way through this list with you, he will be giving directions. He can either write them in his normal record, or he can write them on the checklist, and it can come back for compliance at a mention. If we can look very briefly at the request form, we will see that it has an abbreviated version of the heading from the checklist, and then it starts with question 5 on alternative dispute resolution. The reason being that the first 4 questions are filled out on the checklist. So from here on, the questions and the numbers correspond to the checklist. So if in your request you say that you want, for example, item 6, I want to amend my pleadings, you can fill in as per the draft amended plaint attached here too. And really there's no need for evidence on or affidavits on such an application. Other party may consent, or the judge can deal with it by looking at it there. And the idea is that the judge can deal with these matters in a summary matter and move forward with dealing with all of this. The intention is that if we work through the checklist together with the opposing party and with the judge, that for the judge, there's the certainty that this case is ready for hearing, that there won't be unnecessary adjournments, and that there will not be unnecessary documentation and evidence called. So it's just to shorten the time of the hearing and to allow the judge to get on with the determination of the matter as quickly as possible. The advantage for us as advocates is that we are forced to think about our client's case at a very early stage, so as to know whether we have a good case or what gaps there are in our case and get evidence, and to ensure that we assist the speedy and efficient administration of justice, but also that we present our clients' cases in the best possible way. Thank you, and I believe we deal with questions at the end of the other 2 presentations. Thank you.
Thank you so much, Senior Counsel Fraser, for that meticulous presentation. Thank you for placing emphasis on the fact that the practice of duplication of documents should be abandoned by advocates for ease of practice, that particularly during case management, that advocates should be familiar with their matters, particularly the advocate in conduct of the matter, should be the one attending case management conference to avoid unnecessary adjournments. And the fact that now we have specific applications that should be made at the case management conference, such as issues to do with judgment on admission, striking out of particular pleadings, and not after the completion of case management conference. Thank you so much for that. Now to our next speaker, Mr. Alan Wayaki-Kishuhi. Alan is a consummate litigator with over 24 years experience in commercial litigation. He's an experienced chartered arbitrator, a published author, and has been awarded with the Elder of the Order of the Burning Spear in 2019 for his exemplary service in the area of law reform and service to the country. Without further ado, let us welcome the 40th President of the Law Society of Kenya, Mr. Alan Kishuhi. Alan, you can take the floor.
Thank you, Stella. Good afternoon, honorable judges and colleagues. Mine will be brief. I will just simply highlight issues in the commercial division practice directions from item number 3 to item number 8. And this deals with virtual hearings. Now, before I start with this, I think it's important for me to go to the practice directions to standardize matters in the High Court and bring out some salient features which I think should be imported and also applied in the commercial division. Now, one very important item is practice direction number 17 on time management. Now, at this particular point, the court may allocate time for the hearing of cases. Now, what ordinarily happens is that the judge will inform you that your case will be heard at 11 o'clock. Then another case will come in at about 12 o'clock or 11:30 or thereabouts. And emphasis I'd like to draw your attention to is 17D that says, parties and counsel shall be bound by agreed optimum timelines during sessions. Now, what this presupposes, in my understanding, is like the way we have election petitions. If you've got 4 witnesses in total for a particular case, there's some witnesses who will take more time than others. And at that particular point in time, and this is very important, which will come out during the checklist, is to indicate if you need 2 hours to conclude your case, how will those 2 hours be allocated amongst the various witnesses who will be cross-examined? And ordinarily what happens if we have very poor time management, you'll find that there's an overrun where one witness could take even 3 hours. Yet when you look at the checklist and the issues in contention, there could probably be just about 6 issues. And you wonder, why would one witness hold all the time, and perhaps the issues in contention that the witness would be concerned with are probably half of them. And one thing that we must start to rethink and to readjust, because of limited time now, as we've had the 5,000 cases, which is supposed to be heard in 1 year, is start thinking of handling cases the way we approach election petitions. And judges should now analyze how much time should be allocated to each witness, so that when the case commences, whether physical or virtual, you will be beholden to stick to that allocated time. If we don't do that, we'll never get to have the cases heard within 90 days. The other important thing I need to point out also is that, and this is important when, for example, it may dealing with matters for issuance of dates in the standardization practice directions. If you go to 24G, the rest 24 deals with how dates will be given for hearings and everything, and on the priority manner that will be had. But when it comes to mentions, and this is a very notorious practice amongst us advocates, you're served with a mention notice without specifying what is the purpose of the mention. And if you look at 24G1, it says the purpose and reasons, and must is actually in capital letters, must be specified. So for instance, if you're going to fix a matter for mention for purposes of fixing the case for hearing or for any other purpose, please indicate the ratio disadvantage for that hearing, purpose of the mention rather. Now, part of the issues that are important is that under section 1A, and this is emphasized in rule 40, if you fail to comply with any of the directions, you will be penalized as the judge deems fit. If you proceed to a hearing without your witness statements, without your bundle of documents, and there's an unless order issued, then what the practice that has now developed is that you'll be given a warning that unless you do comply with the court directions or orders within a certain specific period of time, your pleadings shall be struck off. And that would actually be negligence on the part of the advocate, because if, for instance, you're unable to comply with any directions, the most sensible thing to do is to immediately put in an application to cease acting so that no claims of negligence can be visited upon you. We've seen several instances where pleadings have been struck off simply because advocates have not been diligent enough to comply with any directions in terms of compliance or filing witness statements, bundle of documents, or whatever. Now, turning now to quickly because of time, when you come to now the part dealing with virtual hearings, the most important thing is, of course, to be prepared. And that's what Rule 4 virtual hearings is all about. You'll find that in instances, one of the most important things is the person who appears in the virtual court, your name must be there. Just as you see my name, Alan Gishui, there, then your name should appear there so that for record purposes, we know that that is a person who is seized of the conduct of the matter. And remember, the proceedings have been recorded. The other thing is, of course, the microphones. Always switch off the microphones. We've had embarrassing conversations of advocates online, and at times you even forget to switch off your video. So please, for heaven's sake, always be cognizant of the basic issue of switch off your microphone and your video if your matter has not been called out. Now, of course, one of the courtesy is do not interfere if your colleague is speaking. If you want, and this is under the virtual hearings 4H, if you want to draw the attention to the judge that you want to intercede in a matter, lift up your hand and you'll be seen. At times you may just put press the small icon for your hand, but who's going to see that? But just lift up your hand so that you don't interrupt the process of the proceedings. Now, ultimately, whatever conduct, as Senior Counsel Fraser has indicated, that takes place in the virtual court is the same way you appear in physical court in a manner, or in terms of mannerism, in terms of dressing, in terms of addressing the court. So it's the same decorum, courtroom decorum that is expected in physical court that is transposed in the virtual court hearings scenario. Also, courtesy. Do not start drinking coffee or even taking snacks and everyone sees you, because a court is a solemn place. You'll never be expected to carry that, except you can have your glass of water, which is permissible. Now, coming to the issue of mode of calling of evidence, and this is where the court can either, when a witness is called to testify, it can either be through affirmation or by swearing using a religious book. So you may have to have a religious book depending on the religion of your witness present. Now, when it comes to the issue of technology, and this is where we have challenges. Right now, you have to be careful with, for example, what application of Teams are you using? At times, for example, if you upgrade your computer to say Windows 11, and you have two Teams running at the same time, you'll find that even your camera may not be working. So make sure your ICT person ensures that you have got the latest team compatible with the version of Windows you have on your computer. Remember, one of the things is the hearing could take place for hours at an end, and you have to have a consistent power supply. whether it's a UPS or something or generator, please ensure that you have adequate bandwidth and power to ensure that there's no interruption. At times it happens, you may have a cable cut and you expect it now to quickly go into mobile data or something so that you can actually not interrupt the court or lose any opportunity. Now, one of the things that we asked and reminded is please log in 10 minutes before the hearing starts. The challenges we've seen in some instances that you may log in, you log in at 9 o'clock, and then later on if you're told log in much later for your hearing, there could be delays in you being admitted into the virtual courtroom. And that is why it's important to always have the number of the court assistant handy so that you can quickly alert the court assistant of any challenges or predicaments that you're facing. That also brings us to the question of how will you be reached, for example, if you're not having the conduct of the matter. And that's why the practice directions are very clear. The person having the conduct of the hearing should also indicate his or her phone number so that the person can be reached in case of any technological problems that may emanate. And the judges, I'm happy to say that the judges have been very kind enough if there are any technological challenges to have the assistant or even a colleague, your opponent, reach out to you to find out what has transpired. Now, location of witnesses in virtual hearings. The general trend has been that you should have at least your witness alone in the room. Many advocates basically would share a screen with the witness. The other scenario is to have the witness have his own screen in front of him, and you also have your own screen, and the witness must have all documents present. I'm not very sure how efficient the screen sharing of bulky documents is, but the general tendency I've seen is that witnesses would have the hard copy, the physical copy of the complete bundle of documents in front of him or her, and any referencing will be according to the pagination. I once saw a Microsoft Teams, or rather Microsoft from UK. They have got a very unique, the English system has got a very unique manner of projecting documents. For instance, when you file your documents, it's not just the way we file in PDFs, but your documents will also be hyperlinked. For instance, you have your index, it's hyperlinked to a particular document it's referenced to. We have a long way to go to get there, but I'm sure we'll get there someday. But that's how fast they've gone, so that it's much easier for a party to refer to a document page, for example, 800 and something, by just clicking onto the hyperlink and to get there immediately. Now, just like in the physical court scenario, all witnesses should be out of the physical court. Similar with the virtual court, all other witnesses should be in a separate room and only called in when required to testify. As I said, now with virtual courts, you can have your witness from any part of the world, and once they're sworn in, it's easy for them to refer to the documents. As I said, it could be screen sharing, it could be the physical documents, but the complete set of documents must be there. I was once involved in an arbitration where we had a virtual hearing with a witness in Nakuru, and suddenly he could not access and move around the screen documents on the screen. So we had to adjourn for him to have a physical set, because he was also technologically challenged. And that's one of the areas that you have to be careful. Prepare your witness in advance. Have a dummy run trial with a witness in a sort of virtual court scenario, and see how the witness will actually take the rigors of a virtual court hearing. Is the witness prepared to scroll through documents? Is your witness prepared with all the documents? Should the witness just waffle, or should we direct? Please prepare a witness, not coaching, but just prepare a witness to give evidence, just like in the physical court. There's also a very important aspect there for witnesses like children or persons whose identity should not be disclosed, can provide evidence behind a protective screen. And of course, this will be indicated in advance to the judge and to the other party that this is what's going to happen. There's also the aspect of an interpreter in a virtual court. The interpreter also, just like in an ordinary court, would have also to be aware of the procedure and directions that would have to be applied in terms of the virtual proceedings, and also that the interpreter is well versed with the language of the witness and is competent to interpret correctly. And finally, if you require any particular proceedings for a particular day, just simply write to the tape registrar and request for the virtual proceedings for that particular day, which will also assist you later on if you're required to prepare your submissions. So all in all, that is basically an overview of what would be required in a virtual trial and the virtual courtesy that is expected of colleagues. So thank you very much. And any questions can be addressed after the session.
Thank you so much for that wonderful and brilliant presentation. And even just telling us that it is important that we are mindful of time management, particularly noting that as advocates, we seem to forget that time is a finite judicial resource. I also know as advocates, we have a penchant for hearing our voices, particularly when the fee note is slightly healthier. But I think as stakeholders, as you've stated, we must stay true to the provisions of Section 1B on efficient and just determination of matters. Thank you also, Alan, for the reminder that as participants, we must always conduct themselves in the same way and the same decorum that we had whilst conducting ourselves before or conducting matters before the physical court. So our next speaker, and by the way, if you do have questions, kindly write them on the chat box. Okay. So our next speaker is Honorable Elizabeth Tanui. Honorable Tanui is the Deputy Registrar of the Commercial and Tax Division, Milimani High Court. She's also the DR in charge of automation in the judiciary and understands that automation makes service delivery effective and efficient. This has earned her various awards. That is the NLA Judicial Officer of the Year, multiple awards at that. And she's also earned the award of Head of State Commendation. Litigators have come to know Honorable Tanui as the legal sentinel and an integral part in ensuring that the wheels of justice keep turning, as she's the one we go to when we need our matters certified as ready for hearing. And she does ease the burden on our judges. She's the gatekeeper and custodian of these particular practice directions. Let us now hear from her wise counsel, Honorable Tanui. The floor is yours.
Thank you, Stella, for those kind remarks. I'm going to be very brief, counsels. Mine is basically on paragraph 9, 10, and 11, which are the last paragraphs on the practice note. It is to do with exhibits and reliance upon pleadings, statements of evidence, and bundles of documents that have been lodged in the e-filing portal in the physical and virtual hearings. So there are two scenarios. One of the scenario is, of course, a scenario where the judge has certified the matter ready for hearing, but the hearing is then proceeding virtually. What then happens? The other one is the scenario where the matter has been certified for hearing, but it has been certified ready for hearing, but will proceed in the physical space. So the common thread between the two is that pleadings and statements of evidence, those are the witness statements, and the bundles of documents will have been filed in the e-filing portal. At least that is a common thread. One of them, of course, one of the other issue is that they will have been filed within the required time, and two, that they are eligible and that they have been paginated. So in the virtual hearing, what is expected and what has been documented in this practice note, which we have agreed that will be leading us as we go forward, is that once your hearing has been certified ready and is going to proceed virtually, you will then forward the documents which have been e-filed through the court email. And once they have been sent through the court email, then we will be able to share them, display them during the hearing using the function of the share function. The way I shared the practice direction, that is the way you can then display the documents as you're proceeding via the hearing. So what will happen, if you will remember, councils, there was a time when all of us were presenters in the virtual space before we configured the system now to only ensure that it is only the judges and their court assistants who have various rights. So before we did that, you could share any document at any time, you could admit and you could remove participants in the virtual platform. But we had issues about that, it was abused, and the integrity of the court proceedings were in jeopardy. So what we did is that we configured our Teams platforms now so that it is only the judge and the court assistant who has all those rights. So for you to then display the documents that you have forwarded to us via email and share them, you have to seek leave from the judge. So if you're proceeding virtually and you need to use the share function, the judge has to know that you need to do that so that you are then given leave. And the judge who is in court will make you a presenter so that there will be more than 2 presenters. They will be the judge, of course, who is the host. There will be the court assistant, and then there will be you who is then sharing. So we need to know that not all of us can have that right to do that. So you have to proceed with leave from court. So that is in a scenario where the hearing is proceeding virtually. Now, in a scenario where the hearing is proceeding physically, it is the same thing. So we will need the bundles of documents, the pleadings, the witness statements, and the bundles of documents, all of them paginated but brought physically to court. But you will then have to have enough copies so that one is, of course, for yourself. The other one is for your witnesses. If you have various witnesses, then they will be as many as the number of witnesses that you have. And then, of course, for the courts. And it will proceed as usually proceeds in a physical space. So what I just needed to bring to your attention is that it is possible to display documents virtually, so long as they have been paginated, they have been forwarded to us via email, because the person who will help you share would be the court assistant, but you can also agree. We've had hearings where advocates agree, because you already have these documents anyway, that one of you will be the one who is sharing the screen for the court to look at, and for you even to look at as you're proceeding with the hearings. So that is to do with sharing of documents. Just ensure that there are enough bundles. If it's proceeding virtually, then forward to us. If it is physically, let's have the physical bundle brought to us to court. Now, in respect to directions relating to physical or virtual hearings, one, of course, is that whether you are proceeding virtually or whether these proceedings are being done physically, we all need to dress well. These are very formal proceedings. We have seen, of course, as Alan Gishui said, very embarrassing situations where, you know, advocates are not dressed for court, and we know how that goes. So according to the practice direction, paragraph 10, we are supposed to have the right attire, and LSK has a dress code. That dress code should be able to inform how you dress, whether in a physical space or in a virtual space. The other one is use of recording equipment. We have seen scenarios where advocates or even litigants who are in a virtual platform actually screen and record and stream live, broadcast live the proceedings which are appearing before them. That is not supposed to be done unless you have permission from the judge. Please don't stream any proceedings where the judge is proceeding unless you have the permission of the judge to do so. The other one is, of course, and this has been talked about, desist from coaching witnesses. You prepare your witnesses, but of course, desist from coaching them. There is the issue of having many witnesses, and this is a virtual hearing which is proceeding. I know there is a challenge as to how do you manage the witnesses. You have 5 witnesses who are on call. All of them, we share the link publicly, so it is a courtroom, so all witnesses have come on call. So the correct thing to do is to ask your witnesses to be outside the call until they have been admitted. And of course, this you will do in liaison with the judge, because the judge will see how many witnesses are on call. If this is a hearing which has been set, for instance, at 11, sometimes it's difficult to know that there are more than 2 witnesses that are on call. But it is up to you. It is your obligation to ensure that other witnesses who are not supposed to be on call as that particular witness is testifying is not present when one witness is testifying. So paragraph 10D states, advocates and parties calling any witnesses shall be expected to ensure that they comply with the rules of giving evidence, including ensuring that there is no more than one witness. The other witness shall be kept separate from and shall not be present in the room within which the other witness is testifying. So if these proceedings are proceeding in your boardroom, ensure that the other witness is away, and also on call, ensure that the other witness is not admitted until one witness is done. Now, in respect to physical hearings, the practice note has given directions as to what the judges should do. During the mentions, let the mentions be done in the morning. And if a hearing is supposed to proceed thereafter, it should have been mentioned. And during the mention, then time will be given by the judge. For instance, if it's at 10:30, let it be very specific that this hearing is proceeding at 10:30, physically in this particular court, so that as deputy registrars, as judiciary staff, we will then prepare for you to come to court. We will ensure that there is a recording equipment. Now we have 6 courts with equipment, but these 6 courts are being used also by other courts. So we need to ensure that we schedule the cases accordingly, so that we don't overschedule and then we don't have the number of courtrooms and the recording equipment that we need to use. So during the call-over, the judges will then schedule the hearings as per the number of witnesses that will be present. And the practice direction has given guidance that at least 2 hearings per day will be listed in the diary for each judge, while the COVID regulations are, of course, in force. We will hear from the judges whether that is sufficient, but what we are doing now is at least 2 or 3 matters will be listed for hearings, and they are scheduled as such. The court assistant will sanitize the witness boxes and religious books after use by each of those witnesses. So subject to directions from the judge, only witnesses, the parties and advocates will be in court. This is in a physical courtroom. And we are also limiting the number to at least 10 and not more than 15. In a small courtroom, not more than 10. In a big courtroom, the 2 large courtrooms, we have large courtrooms in the commercial and tax division, but not more than 15 at any one time. So we will put in place procedures at the main entrance to the court building for checking, sanitizing, hand washing, and recording and all that. This we still do just to ensure that we have the hygiene regulations put in place. So with that, councils, that is how we will be conducting the hearings. Just to emphasize that it is possible, and it is possible, and we have configured the platform, the Teams platform, to ensure that you share your documents, so that not every hearing should be a physical hearing. If you have documents to share, it is possible for us to enable you share them and display them on the screen the way you would do it in a physical courtroom. Thank you, Stella.
Thank you so much, Honorable Tanui, for that illuminating presentation. Indeed, there is ease in virtual hearings. Particularly, I think the great gain is the fact that we will have documents displayed during hearings, and gone are the days where time would be wasted between stepping away from the bar and actually going to the witness doc to try and trace a particular page or try and trace a particular paragraph. I think the share screen option is a great advantage in the timely disposal of matters. Thank you also for the reminder that indeed the rules of evidence continue to apply, and for the reminder, which again is unfortunate, that advocates must dress appropriately when appearing before the court. I think it is important as members of the bar to ensure that we are the keepers of our profession and that it remains revered. Now, before we go to the Q&A, PJ had wanted to introduce other members or other judges who are actually in this particular platform. Honorable Justice Maber, you could go ahead.
Thank you, Stella. Thank you for having put a very excellent, very professional, very articulate panel which has delivered what was our expectation. Ladies and gentlemen, before we go into the Q&A session, let me call upon my colleagues who are in the house to give one comment and introduce themselves. Let's have, first of all, Majanja Commissioner. Judge Majanja.
And
Judge, we cannot, yes, we can hear you.
You can now hear me. Thank you.
Yes.
Thank you very much for inviting me to this forum. As you're aware, I'm on leave, so I think this is timely. Just two issues. Thank you very much for the panelists. I think as we move along, we'll keep improving. Just 2 or 3 issues which I want us to note. I think it's very important when you, part of the reason we're having problems with the hearings is that we have lost the meaning of case track. We have fast track cases and multi-track cases. I would want to see a scenario where we are very clear that if it is a fast track case, that case is the kind that we can schedule online. And those are the kind of cases you can do 2 cases a day. If we improve our system, we may be able to find that we are able to do more fast track cases and then reserve probably a week for multi-track cases or multiple days for multi-track cases. I've seen situations where parties call a case fast track and they want 3 consecutive days. So that's an issue we need to note. Secondly, just to emphasize, I think it's very important that advocates continue working together, talk to one another. One of the things sometimes I get distressed about, and I think which Mr. Gishui mentioned, you see, if you are served with a mention notice and it doesn't have the reasons for the mention, I would expect that the first thing you do is call your colleague to find out what is the issue. Can we resolve it before we go to court, instead of coming to court and entering into an argument, wasting the court's time. So I'd urge advocates, please cooperate with one another, particularly in pre-trials, agree on issues, agree on documents, agree on as many things as possible so that you don't waste the court's time. And finally, just something we are working on, PJ, the issue of appeals. We have very many appeals that are not moving. So I think towards the end of the month, we will see some action, seeing how we can improve the adjudication and finalization of appeals. And please, we are asking you as advocates to cooperate with us. Thank you very much, PJ and participants.
Thank you, Commissioner, for that, for those few words. Let's have Muita Chacha Muita, Justice Muita. Judge Muita. Okay, let as he unmutes himself. Judge Mulwa. Judge Mulwa. Okay, Judge Okwani. Judge Okwani. Very well. Judge Chipkwani. Judge Chipkwani is our latest, she's been transferred to our division. She takes over from Justice Mulwa as from the 1st of April going forward. Therefore, we thought that because she's becoming one of us, it is important for her to be with us this afternoon. Welcome, Justice Chipkwani.
Can you hear me?
Unmute yourself.
Can't hear me?
Lady Justice.
We can now hear you.
Okay, good afternoon.
Good afternoon.
Good afternoon.
Good afternoon, Judge. We can hear you.
Yes. I just want to thank the presiding judge for inviting me to this session. I've listened, although I joined you people in the middle because I was still in another court, but I've appreciated the sentiments that have been expressed by all the speakers. And just to join the rest of you, I would urge advocates, because this is something I've noticed, because the issue of ambushing one another on the date that matters have been set either for hearing or mention, then one just comes up or springs up with an issue that was not there, and then you have to take a lot of time resolving that issue. I'm glad that was mentioned, because sometimes I get surprised. And the issue of witness statements, the reason why we file those statements is so that when we come to court and we've gone through the case management or pre-trial conference, I always expect that then parties or advocates have gone through the same and have agreed on issues which should be litigated on, or some which they've agreed on, and would then have to take a very short time with a witness if we were to adopt the witness and the documents that have been filed. But you find that sometimes now you take almost 3 hours, as I think Senior Counsel mentioned, Gishui, you take 3 hours on a witness, then yet a court has maybe 3 or 4 hearings on a day. That wastes a lot of time. Otherwise, I appreciate and I'm looking forward to working with you from 1st of April. Thank you.
Thank you, Judge. Thank you, Judge Dora. As we wait, I think Judge Okwan is joining us shortly. I think I have two observations to make. In order to streamline the hearing as we move forward, as in the division, what we are trying to do, I think Senior Counsel Allen indicated. I think it's Tanui who indicated we will be listing 2 hearings. Always we will start with the oldest case, but the part heards will be given the priority so that we can be able to conclude matters as soon as possible. Then we'll move to the second priority will be the oldest matters. Then the adjournments for the part heards will not be beyond 3 months. It means that probably new cases may have to give way for the part heards, because it is very inconveniencing when a judge is probably transferred and he leaves behind 100 part heards. It becomes very difficult for incoming judges. So what we'll be doing, we'll be trying to make sure that we adjourn. The maximum is 90 days within which we can be able to proceed and finalize. Now we have Lady Justice Okwani. Please, Lady Okwani, you say a word. Unmute, please. Unmute yourself.
I'm sorry for that. I'm not using my normal device, so that's why I'm having a challenge. I'm at a colleague's chambers. I'd stepped out a little. Thank you so much, the council on record or on the platform and colleagues. I'm so grateful for the presentations that have given us a way forward in the manner in which we'll be handling proceedings before us. The recommendations or the provisions are very useful, and I hope that we shall all walk this journey together so that we can dispense justice to Wanjiku in the most efficient manner. Thank you so much for this session. Asanteni.
Thank you, Judge. Thank you, Judge. Thank you, Judge. Colleagues who are in this meeting, I don't know whether Muita has come back and Mulwa, but as you are aware, judges, we got bereaved, and most of the judges this afternoon had gone to the deceased home in Karen. But those of us who were able to be with you, because this was a very, very important session. And I'm really grateful, Muragori, for having put that very efficient team which has delivered home the issue of our practice directions, which I promise that starting next session, we will strictly try to enforce them so that we can have some efficiency in our division. Thank you so much, Muragori, back to you.
Thank you so much to all the judges who have made time to show up for this particular session and for the comments that you have made. For the sake of saving time, we shall dive right into the questions that have been posed in the chat box. I think the first question is by Atieno Otieno, who asks, I think this question can be taken up either by PJ or Honorable Tanui. Is there a way we can cascade the same practice directions to all subordinate courts? Honorable Tanui, you could take that, or Justice Maber.
Thank you. Thank you for that question. I'm sure Justice Maber will echo what I'm saying about we now have a commercial division at the lower court, that is at the Chief Magistrate's Court. So one of the things that we are trying to do is to ensure that what is accorded to a commercial case in the High Court is the same practice that will be accorded to the same case at the lower courts. So there's a conversation which is going to happen with the Chief Magistrates and of course with the CJ, that what is happening at the commercial division should be cascaded down to the commercial division in the lower court. So thank you for that question. It is a conversation which is live, and we thank you for that feedback. Judge.
No, that's all. What you have said, that is the position. Moreover, you can proceed.
Very well. Carol Gizai has a similar question to Clifford Othiambo, which is it possible to have the assistant's phone number and the court's email displayed on all cost lists?
So let me take that. The Law Society, that's the Nairobi branch, the bar, this bar section of the bench, there is the bar bench committee, but the bar did buy us phones. Every court has been bought a phone, and we really thank the Law Society Nairobi branch for coming through for us. What we are doing is that we are recording them and having the chief registrar give us official numbers. It has taken some time, but starting next term, every court will have an official number so that we are not displaying personal numbers of the court assistants. So we already have a gadget, but we will have official numbers for those courts. So from next time, you will see a court email address and also the official phone number for that particular court. So that when, for instance, a court assistant is away on leave, that same number will still be displayed, and the person who is standing in for that court assistant will be the one who is picking that phone. So you will see a difference in our court list come next time. Thank you.
Okay. I think the next question is equally to you.
Stella, if you could read the question, sorry. Sorry, yeah.
The question from the firm of Kaplan and Stratton. The requirement is that the advocate should log in 10 to 15 minutes before the matter is scheduled for hearing. So does this mean advocates will not be allowed when session has started? or will they be disconnected and allowed to log back in?
This one will be, yes. I think the idea is just to have all advocates log in at least 10 minutes before, so that by the time the judge is starting, we are all ready for, for the court session. But if you log in thereafter, the issue will be with, for instance, Justice Okpani's court. I know that it's Justice Okpani who is the one who is admitting advocates. So sometimes judge is busy, listening attentively to what is happening before her court. So sometimes it takes time to log in, to admit the advocates. But we will enable the court assistants to have laptops and also have their own accounts so that they can then help the presiding judges, the judges, to admit those who are outside the courtroom. But we will endeavor, I think the practice direction just ensures that, you are there before court starts, but even as the court proceeds, we will ensure that you are admitted. So we will enable the court assistants to help judges do that.
The next question is by Paul Ogunde, who says, with the objective being expediting matters, how does the court-mandated mediation space speak to the adjustment that the directions portend? He says it is unclear how matters are screened for mediation and where the pretrial preparation process sits in that consideration. He further states that there are cases where several interlocutory injunctive applications have been resolved many months or parties later, and then parties are thereafter sent to mediation, which is generally abused as a holding ground in terms of delaying the matter.
The judges can answer that. Thank you.
Honorable Justice Mabea, perhaps you could take that up.
Very well, thank you. On the issue of, I think still our section, the registry for mediation is still active. It is not a must that the matter must have gone to case management before the screening is done. Deputy Registrar Wanyama's docket is active. And on the issue of people being sent to mediation after injunction applications have been heard, I doubt that. I don't know whether it is a practice which we are doing. We are doing it now or not, because people are supposed to be sent to mediation when still the heat is on, and the heat is usually on before applications for injunctions are heard. I don't know whether Mr. Ogunde have answered your question well.
Well, I would hope so. In case there are any follow-up questions, I think you could actually write them. Then the next question is by E.M. Dichu, who asks, there are bound to be technological challenges in screen sharing. What are the fail-safes? I'll have that question answered by Honorable Tanui.
Thank you. I'm happy to take that question. The reason why the practice direction then guides that you send to us the bundle that you expect to share through email, so that if there is an issue with your sharing, the court assistant will then assist you with the sharing of the documents on display. So if you could send it to us earlier, and the hearings that have happened virtually, it is the court assistants who are the ones who are sharing, of course, being guided by the judge and at the request of the parties. So before you do the screen sharing, just ensure that we have that document so that if you have a challenge, we can help you with the sharing. Thank you.
Still on the issue of the bundle of documents, Anthony Njogu says that there are instances where opposing counsel's bundle is different in pagination or even in terms of the actual documentation. And this basically confuses the system. And then Judge Dongo says, or is suggesting, is it possible where we can have documents filed jointly so that then they're produced by consent for ease of screen sharing and referencing? Honorable Tanui.
I think Mr. Ndungu has answered the question with that suggestion. And I think also the case management, just as shared by Mr. Fraser, if we all go through that checklist and do tick the boxes. Then we will have an agreed bundle of documents. Then the documents which have been disputed will be separated. It will be known that these are separate. I mean, these are documents which are disputed. Those are the documents which we will then help share during the virtual hearings if parties are contesting on the same. So if we just follow the checklist, tick the boxes, it will be clarified. These are the documents which are not disputed, and then these are the disputed documents.
Very well. Thank you for that. Unfortunately, a lot of questions are coming your way, Honorable Tanui, so you'll have to take the heat on this one. The next question is actually a suggestion by Andrew Jenga on whether the cost list can be released weekly and on Fridays with the court clerk numbers in order for advocates to ensure that their matters are listed and have had time to speak with the court clerk and registry.
Yes, it is possible. We, I think, did that the first 1 month, but because of the many cases that we list in our list, sometimes we don't do it weekly. But the same cause list that we have, and I'm bringing this to the notice of the advocates, you can actually get our cause list up to June, up to August through the e-filing portal. If you go to the reports, the interface that I have is the interface that you have. If you click on the cause list for the division for next week, you can actually have that cause list if you download it. So make use also of the e-filing portal that you have and get the entire cause list for the entire year for the division without necessarily waiting for us to post. What we post would if we have an application which has been added because it's under urgency, those are the ones that you will see added. But the cause list that I would post is the same cause list that you will have through the portal. Thank you.
Just to also add on to that, and I think I can see Alan Gishori has made mention to it, when we look at the standardized practice and procedure, practice directions, and direction number 25, it actually states that the cost list for the month should be prepared and posted online a week before the end of the month. So perhaps even as we're adapting that, we can also make reference to practice direction number 25. The next question.
Sorry, Stella, I needed to just add, if you have a matter, for instance, which has been, you have a list, you have a date, and when you check through the portal and you're not seeing that activity updated, that is a red flag for you, that matter most likely would not be in the cause list. Because our cause list is auto-generated, it means that for it to be in the cause list, the activity must have been updated. So if you see that the date that you have is not reflecting in the portal, please let us know, because that is already a red flag that either because of omission or sometimes even intentionally, somebody just failed to update for purposes of ensuring that you are not in the cause list. So let us know beforehand that the activity that you have been given is not updated in the e-filing portal. That's just one of those things that advocates need to know. Thank you.
Okay, I think we are coming to the tail end. There's a question by Clifford Othiambo who asks, what measures have been put in place by the registry to assist self-represented litigants rather than dealing directly with the judges or chambers assistants in order to assist them through the application process efficiently? And then he also asks, what measures will be put in place by the registry to ensure urgent and not urgent interlocutory applications are brought to the attention of the judge who has the responsibility for hearing that urgent application and are not delayed due to internal administrative issues at the registry? Honorable Tanui, again, this one is yours.
Thank you, Stella. I also have my colleagues, Honorable Claire is on call, Honorable Stephanie, they'll help me answer one of the rest two. I'll take the first one. The first one in how do we assist self-representing litigants? We have an e-filing support center just outside the Milimani law courts. At the customer care desk, we have an e-filing support center where litigants who are technologically challenged are being assisted. The other one is, of course, we are having the Huduma centers soon operationalized by the CJ. So they will also be assisted through the Huduma center desks that we will have with effect, I think, from May, once the CJ has given the green light for that to happen. I'll invite Honorable Claire to answer the other question together with Honorable Stephen. So as they unmute themselves, it was on the issue of applications under certificate of urgency. What has now happened through the e-filing portal is that applications under certificate of urgency are auto-allocated to judges. So what used to happen before is that the applications would be taken to the presiding judge, and then the judge would allocate them to the various judges in the division. But that role now has been taken over by the system. We have configured the system in such a way that the role that was being played by the judge is now played, automated. So once an application has been filed, the judges deal with those applications within 24 hours. And we have seen that work in the Commercial and Tax Division. So that if you file an application after 3 today, right now it is, yes, it is some minutes to 4. So any application that is filed now will automatically be given a date for tomorrow. So it will be deemed that you have filed that application tomorrow and it will be dealt with tomorrow. But applications that have been filed before 3 will be dealt with within 24 hours by the judges. And that is happening, and litigants are getting directions and orders through the portal. One of the things that will also ensure is that one of the phones that was bought was also bought for the registry. The registry will now have a phone and a number where litigants can get through to the executive, that's the court administrator, in real time, just to seek directions and, if they are having a challenge, and queries can be answered in real time. Thank you.
Then we have a question by Caxton who actually makes a suggestion. He says, I would suggest that courts do minimize on the time for mentions so that there's adequate time for hearings. If matters are mentioned till midday, there's a likelihood of the court hearing the substantive matters. There's a likelihood, the likelihood of the court hearing the substantive matters will be minimal. Suffice, there's some applications that can be had by the DR under Order 49. Some of such applications cloud the judge's cost list when such applications ought to be had before the DR. For instance, why list adoption of consent before the judge if the same can be adopted by the DR? Honorable Tanui, Honorable PJ, perhaps any of you could take this up. There's also Honorable Onyama and Honorable Githongori.
I think Judge Majanja, you wanted to answer that?
Yes, I just wanted to say how mentions are dealt with really is a function of advocates. We've talked about, first of all, advocates fixing mentions. Of course, the court will fix mentions. But once we get into the habit of compliance, we'll reduce the number of mentions. Number 2, part of the time that is spent on mentions is advocates arguing over minute things. So if you know a matter is coming up for mentions, please call your colleague, find out what the problem is and how you resolve it. I think to me, that would go a long, long way in reducing the mentions we have. And of course, interlocutory applications, again, it's not judges who file them, it is advocates who file them and they have to be dealt with. So again, that is really a function of advocates. But the thing I wish just to emphasize, and which I have known, is that once advocates cooperate, the time taken for mentions is very little. Thank you, PJ. Thank you, Ms. Moraguri.
Thank you, Mr. Majanja, for that, for those comments. But the promise that we'll give here is that as judges, we will see what will moving forward. I agree with the. If you see the post by Alan, that is the way to go. Hearings should start ideally at 10:30. What we'll have to do is that we will try and change the way we deal with our course lists so that we start with hearings, so that as the first thing the judge does is to fix the hearing at 10:30. Then the matters which are going to be taken out, they are taken out. And then when we come to the hearing of the applications and mentions, if you cannot be reached, let the judge proceed with the hearings, because that will, in a way, so that we can discourage the crowding of the court list for matters which substantively do not help the delivery of justice or finishing of matters. Thank you.
The next question is by Paul Kiranga on time frame on rulings and judgments, but I think I can see that has been answered by EM Dichu, who says that Order 21 does provide for this. And then finally, the last question is to the Honorable DRs. Esther asks, how soon can transcripts be availed to parties?
So depending on the requests that you make, what we have done is that we have a partner who is working with us in terms of management of transcripts, and that is the AJIRA through the Ministry of ICT, where we have young people whom we give recordings in segments, and then we have a BPO who is, of course, taking all of them and merging them together, and you get your recording. So we have a quality control team within the judiciary. Once we have a transcript from this team, they go through the transcript to just ensure that it is a true reflection of what happened in court. So with that team working with us, we are able to get your transcripts in good time. What is happening is that advocates just maybe are not being aware is that they are not requesting, they request at the end of it. So we have to get several transcripts, are requested for. If you could be requesting for transcripts, and we are trying to also have them availed without you requesting. Sometimes we have all these transcripts. We just are holding them, of course, waiting for your requests. But if you could be requesting for transcripts immediately a hearing has been finalized, then you will get them as the hearing proceeds. So if today you're having a hearing, please ensure that you request for the transcripts for that day. If it is next week, ensure again that you request for the transcript for that day, so that we are able to get your transcripts in good time, other than waiting. And then now we have to request for transcripts for last week, the other week, and then the other week. And then these are different recordings at the same time. So if you could help us manage that process, we will also be fast. But I haven't answered the question, the time frame. We are saying within 24 hours of the court rising. Sometimes it takes longer than that. But what we have given ourselves as the ideal time is that within 24 hours, you should be able to get your transcripts. So we should be kept to that.
Very well. Thank you for your questions. In the interest of time, we'll have to call a stop to that. Would also, as members of the bar, would want to pass our deepest condolences to the judiciary and the judicial family for the loss of Honorable Lady Justice Thuranira. It is indeed a heartbreaking moment to lose a colleague and someone who was instrumental to the judiciary. Now I'd like to pass on this particular session to Honorable Tanui to give her closing remarks. Thank you, members of the bar. Thank you, members of the bench. We do appreciate your time. Do have a good afternoon. Honorable Tanui, you can therefore give your closing remarks. And
there was a hand raised. There's just one more hand raised. If you could give Amanya the chance to maybe ask the question, and then I will be asking, I will not do the closing remarks. I will, out of courtesy, just give the presiding judge to do the closing remarks, if not Honorable Justice Machanja. Amanya?
Yes, I think it is a good evening, colleagues, judges. I think for me, the question I'm having is, in this era of technology, we are having people who are hacking our emails, we are having all manners, and I think it is the time that we really need to deal with the issue of these masqueraders and the quacks. So as the judiciary, we faced with technology. We understand now people calling themselves our names there's a high chance. How do we intend? Because as a society, we are very keen on seeing how we can implement together with the judiciary Or are there some areas where the judges feel that we can be able to corroborate and fight this issue of quacks, especially in filing pleadings electronically, because now you don't need to be at the court physically, and attending also court now is becoming, it is online. Is there a way that that issue can be addressed, that we fight this nomenclature that is amongst ourselves, between the practicing lawyers, the judiciary, and us as advocates? Thank you.
Justice Mabea, you could take that question as you close.
Elizabeth, you should have answered that question because it is more on technology. You are in automation, you know very well. Before I close.
Okay, Judge. Thank you. I think I will throw it back to the Law Society of Kenya because they are the ones who are regulating the practice of advocates. So it is us together. What we can do, we have done. For you to have an e-filing account, of course, there are credentials that you need to show that you are an advocate. For you to appear before the court virtually, I think that is for the judges. It is just the way advocates appear in a physical courtroom. What is there to show you that this is an advocate who has, a practicing certificate? This is a qualified advocate. So it is for us to deal with it, all of us together. Just the virtual platform is the same as the physical space. But the e-filing portal has been configured in such a way that we have placed all those security features. I know we have had one or two issues where somebody had to file an application using somebody else's credentials, but it's because these credentials were passed to that person. So how is it that you can give away your credentials? How do you keep your account the way you have your own bank account, and you don't give your password to every, Tom, Dick, and Harry? So it is for all of us together to ensure that we maintain the integrity of the registry, which is the e-filing portal, and of course the integrity of the courts. PG.
Alan, I had the word. You wanted to say something to add on that, please?
Yeah, yes, thank you, Judge. Section 23, 2A of the Advocates Act. Now, I remember 2 years ago during my tail end as president of the Law Society, we issued a sort of practice directions to colleagues that under Section 23, 2A, that requires that the Law Society shall issue a stamp every year to an advocate bearing his practice number, his admission number, his name. And we said, look, that's a bit impractical, but why don't you adopt this, that going forward in all pleadings, and this is what I personally use in my firm, you put in a table form, on the left side, your firm identity. On the right side, the name of the advocate dealing with the matter, admission number, practice number, email, and telephone as a standard practice. I think we should adopt this going forward. And you'll notice that you reduce the number of quacks appearing in court, and also at the same time, we will become more diligent in getting out our practice certificates. I think that could be a simple way to complement Section 23, 2A of the Advocates Act. Thank you, Judge.
Thank you so much, Alan. I hope that the Law Society takes up from where you have left. That will be very, very important, because as the number of advocates increase, the number of quacks increase, as the number of, the room for economic activity decreases, the number of people who look for shortcuts, masqueraders, will also increase. So the earlier we take steps to remove them from the field, the better. Thank you so much, each one of you who turned up today. First of all, I will thank the Senior Counsel's Fraser, Alan, Muraguri, Tanui, for putting this up, because it is an eye-opener. Believe you me, we will try to put strictly to put these practice directions into practice come the next term. And as we move forward, I know there will be teething problems, but it will be for our own good and for the betterment of the justice system in our division. Therefore, thank you so much. I hope you get this copy so that as we open in April, on 20th April, we'll be able to move forward in a united manner. Thank you so much. Good afternoon and good evening.
Thank you, Honorable Justice Mabea. That brings us to the end of our first virtual Inns of Court for this particular division. As I said before, thank you for your participation and do have a good evening.